My name is Alexandra Lofermo. I am in the TD session number 132, level B. My TD session is the Wednesday. For this bonus question number 2, I could describe an important law issue. I have chosen the fundamental case Donoghue vs. Stevenson of 1932. This decision established the modern concept of negligence in English tort law. In fact, the rules of tort law are generally judge-made, and negligence is a failure to exercise the care that a reasonably prudent person would exercise in like circumstances, and includes a duty of care. The legal concept of duty of care created by the House of Lords provides that you must take reasonable care to avoid acts or omissions which you can reasonably foresee will be likely to cause an injury to your neighbor, and you ought reasonably to have in contemplation persons who are closely and directly affected by your acts. Moreover, it is one of 4 types of wrongs for which the law of tort offers remedies. The fact of this case as follows. The claimant, Mrs. Donoghue, had gone to a cafe with her friend. She had brought ginger beer. Then she had poured some of the drink into a glass and consumed it. But when she poured the rest, she found the decomposing remains of a dead snail. She became sick. She suffered from shock and severe gastroenteritis, so she had brought a claim of tort negligence against the manufacturer. The judge of this case, Lord Atkin, had defined the neighbor principle. He stated that a neighbor was anyone who is so closely and directly affected by my act or failure to act that I ought reasonably to have them in my contemplation. This principle was derived from the Christian principle of loving your neighbor. Then this concept existed prior to Donoghue case, but it was generally held that a duty of care was only owed in very specific circumstances, such as where a contract existed between 2 parties, or where a manufacturer was making inherently dangerous products, or was acting fraudulently. There was no contractual relationship between Donoghue and the drink manufacturer, or even the cafe owners, as Donoghue had not ordered or paid for the drink herself. Also, there was a contractual relationship between the cafe owner and Donoghue's friend. The friend had not been harmed by the ginger beer. Moreover, this case is an extension of a principle articulated by Benjamin Cardozo in a case Macpherson vs. Buick Motors Company. The effect of the Donoghue case was to allow such people to bring negligence claims in any circumstance where the conditions for establishing a duty of care were met. In 1990, the House of Lords revised Lord Atkin's neighbor principle to encompass public policy concerns articulated in the case Caparo Industries, Peak vs. Dickman. The 3-stage Caparo test for establishing a duty of care requires foreseeability of damage, a relationship characterized by the law as one of proximity of neighbor, and the situation should be one in which the court considers it would be fair, just, and reasonable that the law should impose a duty of given scope or one party for the benefit of the other. So, to conclude, this fundamental case, Donoghue vs. Stevenson, laid down 4 main principles of law. First, negligence is a district tort. Negligence as a tort or civil wrong which could be actionable in any circumstances in which one person suffered of personal injury or physical property damage as a direct, close, and foreseeable result of the act of or omission of another. 2. A contract is not necessary. 3. Manufacturer's liability liability. This case related to the opposition of liability on manufacturers under certain conditions. Furthermore, this principle extends not only to manufactured products, but also services as sport and recreation organization, which provide services and must ensure that such services are safe for all the participants. And 4. The neighbor principles.